Ryan Klein is a member in the Sherman and Howard litigation, trial and appeals, construction, and government contract practice groups. He works out of our Colorado Springs office and has over 11 years of experience focused almost entirely on government contracts and construction. He regularly advises clients regarding government contract construction matters at the federal, state, and local level at all stages of the process, from project inception through completion, and has extensive dispute resolution and trial experience. Ryan is a frequent presenter throughout Colorado on behalf of the National Contract Management Association and Colorado Procurement Technical Assistance. Ryan, it's all yours.
Thanks, Brett. So today we're talking about the CGA's changes to the Procurement Code in House Bill 17-1051. And just as a small background, the Colorado Procurement Code can be found in Title 24, Articles 101 through 112. It was enacted in 1981 and went into effect at the beginning of 1982. It was originally based on the Model Procurement Code, and that'll kind of play a part in some of the changes here. There has been some modifications over the years, but House Bill 17-1051 was kind of the first real major modification to the Procurement Code since it was enacted. So a little history on the bill. It was introduced in the House at the beginning of the session, passed out of committee without a single dissent. It took a little bit of while, but the second it left the House, immediately introduced in the Senate, again passed out of committee without a single dissenting vote, and then passed the Senate unanimously, and then was fairly quickly signed by the governor. One thing important to note is, to my knowledge, it wasn't opposed by any trade organization. In fact, a fair amount of trade organizations have been involved in the negotiations and drafting of it, so it was pretty well received by the community. When does it take effect? So you don't need to rush out and worry about it taking effect today. There is provisions in all Colorado statutes that provide for when a statute will take effect. So assuming that there is no referendum petition, which there isn't likely to be one given the little opposition to this bill, assuming the CGA adjourns on time on May 10th, this should go in effect on August 9th. We'll keep you up to date through notices if there's any change in the date of it going into effect. So the scope of the Colorado Procurement Code, if you look at the name, you could think this might apply to every single contract that the state of Colorado does. But if you look at the definition here, it only applies to publicly funded contracts entered into by all governmental bodies of the executive branch. So one thing to note here is this only applies to the executive branch. It doesn't apply to the judiciary. It doesn't apply to the Colorado General Assembly, although they don't do a whole lot of government procurement. But it also only applies to the state of Colorado, so it doesn't apply to municipalities, doesn't apply to the cities. There is some exceptions, and the exceptions can be, some of them are fairly large. The first is it does not apply to bridge and highway construction. So the Procurement Code does not apply to CDOT. It also doesn't apply to grants. It also doesn't apply to professional services. And they added a few new categories this year, some having to do with intellectual property. Then you also had utilities and real property. But not a whole lot of huge changes to the scope of the Procurement Code. So the changes, kind of the magnitude. There's a lot that was changed, and at the same time, there's very little that's changed. So there was some major changes, and we'll talk about them. One example would be bid protests, which we'll spend some time talking about. There's also some fairly minor changes in that we changed the term change order to be contract modification. And then finally, there's just some revisions to match procurement practices, one having to do with the frequent use of requests for proposals instead of invitations for bids. So here are some of the major categories of changes we're going to discuss today. We'll start out with procurement training and ethics. We'll then talk about market research, methods of selection, so the means by which the executive branch will decide to pick a awardee. We'll talk about length of contracts. We'll talk about the contract management system. We'll then talk briefly about new prohibitions on certain contract terms and conditions. We'll then get into detail on bid protests, bid appeals. We'll talk briefly about some changes to suspension and debarment and contract controversies. And then we'll talk about some important changes to confidentiality and CORA. And then finally, we'll talk about preferences and goals. And there's one item I didn't add. Quickly, I'll note changes on the requirements on the length to keep documents and the right to audit. So first, on procurement training. And this is an entirely new provision. So the Chief Procurement Officer may develop and conduct procurement education and training programs for employees of governmental bodies and for vendors. So the Chief Procurement Officer is somebody who is designated by the Director of Personnel and Administration to be his or her designee, essentially running the show for him or her. And there's two keys here on this procurement training. The first is may. It is permissive in the sense of there is nothing out quite yet, and it's not required. And the second is this doesn't apply to just employees, but it also applies to vendors. And so what we can expect in the future is, pursuant to the Procurement Code, the Executive Director and the Chief Procurement Officer, through the Executive Director, have authority to issue rules. So we're more than likely going to see some rules come out administratively that are going to fine-tune this procurement training and what it means. The second new provision was ethics. And this first part here is the previous provisions that are required of state officials. So state procurement officials have to comply with a document that's called the Procurement Code of Ethics and Guidelines. This is a 16-page document. It has some general principles with some specific guidelines. This has been interpreted, however, only to apply to state procurement officials. So it doesn't involve anybody else in the procurement process, i.e., it doesn't involve any ethic requirements for vendors. Here's one example of a principle. State government officials must identify and strive to eliminate participation of any individual in operational situations where conflict of interest may be involved. That principle then provides three specific guidelines. A state employee can't have a controlling interest in a firm that does business with the agency. A state employee can't accept trips, lodgings, meals, or tickets. And obviously there is an exception on meals for value. And then the state employee cannot provide inside information to prospective bidders. Now, House Bill 171051 did adopt that procurement or that ethical requirements. But here's what it does say at the bottom here. The requirement is certain individuals shall enhance the proficiency and stature of purchasing process by adhering to the highest standards of ethical behavior. Now, this applies to state procurement officials who already had requirements of ethical duties, the end users of goods and services. So these are the agencies for whom we're receiving the benefits of the purchases. We now have vendors and contractors who have to adhere to ethical or highest standards of ethical behavior, and interested parties. The thing to note here is I can't tell you for sure what that requirement really means in the sense of everyone's ethical standards in procurement could differ greatly. So what I think you will see in the coming months after this statute becomes effective in August, either this year or early next year, is the executive director or the chief procurement officer promulgating rules more specific to ethical behavior. Something new this year, market research. So for those of you that are familiar with government contracting, this is nothing that's new to you. The federal government has conducted market research relating to procurement for decades. So now procurement officials may conduct market research prior to selecting the method of source selection. Again, the method of source selection is whether you use an invitation for bid, request for proposal. And so the procurement official can now send out a request for information on a market or type of service when there's not enough information for either a specification or a statement of work. So this could be two types of areas that a procurement official could seek help. One is seeking assistance in preparing a specification or a statement of work. Of course, this also always leads to the situation of if you have a contractor helping participate in preparing specifications and statement of work, at least in the federal arena, you also have to start worrying about conflicts of interest later down the road. But for that contractor, obviously this is something that's beneficial for them, because the more they participate in preparing the specification and statement of work, the odds are it benefits them when they actually then submit a bid or proposal. That procurement official can also ask for pricing information. Now, of course, that's something that's going to be very sensitive to vendors and contractors, so we'll discuss confidentiality relating to market research a little later in this program. So methods of source selection. Previously, the default method was competitive sealed bidding, and then there were exceptions for all the other methods when that was not practical or not advantageous. Now, the practical effect was over time, most procurements were done by request for proposals anyway, so the exception was really swallowing the rule. So what you have now is the CGA has cleaned up the procurement code to take away any default method. And we're just back to the traditional methods of procurement that you generally would use and generally have in government contracting as well. No longer do we call it competitive sealed bidding. We use the common term of invitation for bids, invitation for best value bids. You obviously have your traditional request for proposals, and you still have the same sole source and emergency contracts. There wasn't a whole lot of change to these provisions other than changing some names and eliminating some redundancies. Multi-year contracts. Currently, and it still remains true, multi-year contracts can be entered into by executive branch other than CDOT for as long as in the best interest of the state. It must be in the solicitation, and it must be funded for the first year. Now, this is kind of odd in the sense of, at least compared to government contracting, where you have contracts that are generally only one base year and 4-year options. The state could have a contract be 10 years as long as they can justify it, and the justifications are pretty low hurdle, best interest of the state. Anybody could probably come up with a good justification for having such a long contract. But now what you have is that contract, whether it's 1 year, 5 years, or 10 years, can be extended if the chief procurement officer finds there are extenuating circumstances and it's in the best interest of the state. Again, not huge hurdles as far as the best interest of the state. Extenuating circumstances, I think if you compare this to other procurement codes, would probably mean that the state can't or shouldn't be extenuating this if it gets to the end of the contract merely because it hasn't planned or prepared to do a new solicitation. But there actually must be a legitimate reason in the sense of they need additional security or they need some other services for 6 more months because of some emergency. Now, the extension, though, can only be for a quote-unquote a reasonable time period. Obviously, that's not defined, and obviously that's subject to a lot of different interpretations. So you could have fairly long contracts that could be extended for an even longer period of time before we now have new solicitations coming out. Contract management system. Some contractors didn't care about this. Some contractors really disliked the contract management system. The bad news is it's not going away. The good news is it's being repurposed. So it's now going to be a repository of information for what they're calling legislative, executive, and public access. However, they are removing the contract monitoring and reporting requirements. We'll talk about monitoring in a second, but as far as reporting, there were previous requirements for agencies to have to report to the Colorado General Assembly about contracts. That's now being removed, and the legislative can look at the information themselves through the contract management system going forward. So the important point for contractors and vendors is the contract monitoring. So previously, upon completion of a contract, governmental body would evaluate the vendor's performance. The vendor could then dispute that information if they disagreed, for instance, that the agency found its performance to be deficient in some manner, and there was an appeal process. But this information would then become public and part of the contract management system. Now, that evaluation is eliminated, and that evaluation being eliminated is not in the public record. And the information that you have is a lot more basic as to identification of the contract, who won. There's provisions as to performance within the United States and state of Colorado, but it's just some really basic information. However, contractors and vendors are not quite out of the woods yet. What the state did is they retooled a previous statute and moved it into the procurement code in a different section, and this had to do on monitoring of vendor performance. So there still will be performance measurements and standards, and the statute says that these are to be negotiated between the agency and the contractor, and they're in the contract, so these aren't some extra contractual provisions. And there still must be monitoring requirements to evaluate a vendor's performance. And the vendor itself has to also give regular updates to the agency on its performance against those measurements and standards. And there's remedies for noncompliance. The traditional ones that were there and still exist are the agency can terminate the contract. The agency can seek to have returned all the money that it paid to the contractor. And you'd probably say, well, that's really unfair. How can they force us to have to give back everything that we received for value provided? And the next sentence goes on to say, except for the contractual value that the vendor has provided. But of course, that could lead to some disputes in that the agency could argue that the vendor received more in compensation than the value it provided. So there is still some area of dispute there. What this bill did add, though, is it expressly now provides that a contractor's failure to meet these measurements and standards is a basis for a contractor to be suspended and debarred from future awards with the executive branch of the state. Now the difference is this information is just not publicly reported in the contract management system. Contracts, terms, and conditions, this is a new section that was added, although really none of this should be much of a surprise because hopefully state agencies aren't putting these provisions in there anyway or agreeing to these. So one is the state can't agree to indemnification or hold harmless provisions of any other person. Second, the state can't agree to binding arbitration or any other extrajudicial dispute resolution where the final resolution is not with the state. So there can be dispute resolution provisions, albeit they can't be binding in the sense of you could have a non-binding arbitration as long as we're going to have the state ultimately deciding it. And finally, the state can't agree to limit liability for another person for injury, death, or property damage where it's caused by the negligence or willful misconduct of such person or agent. Again, these are fairly obvious provisions that the state probably doesn't ever agree to, should never agree to, but if they do happen to fall into a contract, they are void. So if after August 9th you find these in your contract and you think you have an aha moment, this statute will invalidate those. And finally, another change, but really shouldn't be surprising, is state contracts can only be governed by Colorado law. Bid protest, bid appeals, this is kind of the meat of the changes and will be kind of the meat of what we'll be talking about. So bid protests are a chance for a contractor to object to either the way in which a solicitation is put out or the way in which the solicitation was conducted or awarded. Previously, these had been filed with the head of a purchasing agency. This has now been changed throughout the code to be a procurement official or his or her designee, which is a slightly lower level down. Previously, the deadline to file was 7 working days, which is now 10 business days. And the trigger for that is after the aggrieved party knew or should have known of the basis for the protest. So if we're dealing with a solicitation that a vendor or contractor thinks is defective because it is ambiguous, it would be 10 business days after they receive that solicitation. Now, if it deals with what is an alleged improper contract award, it's 10 days after the contractor receives notification that it is not the successful awardee. Now, the Colorado Procurement Code was changed to use aggrieved party as the only person who can file a bid protest. That means an actual prospective bidder, offerer, or contractor who believes that he or she or it has suffered a denial of legal rights under the code in connection with the solicitation or award of a contract. What that means is if you feel like you've been wronged you get to file. However, what that definition does entail is the party that is the awardee doesn't really have rights as part of this bid protest, bid appeal process. What we're only dealing with is someone who has feel they've been wronged. Now, this deadline does have exceptions for small business, small purchase solicitations, although those aren't likely to apply very often. Once a bid protest is filed, the procurement official will then have, or previously had, 7 working days to file the response. We're now dealing with 10 business days. As you can probably see, they made a change, albeit small change, from working days to business days, but they did give some additional time for procurement officials to come up with their decisions. And this second subpoint here is a new change. If there's no decision within 10 business days, it's deemed denied. This is a principle that's similar to federal government contracting in that when government officials don't take action, that party can then move on instead of being in this kind of quagmire gray area of what does it mean when the government doesn't take action. And this is important, as we'll talk about in a second, because contractors and vendors will then have to move on to a bid appeal. So during this time period, contracts are not awarded, and this is the way it's phrased, although the title of it is stayed. Now, there could be this argument of, does it really mean not awarded or stayed? The practical effect is really the same. And what this means is during the filing of a bid protest, there's not going to be a moving forward of the performance of the contract or award of it until that bid protest is ruled on by the procurement official. However, this provision says it only applies to RFPs. So if you're dealing for invitation for bids or some other procurement method, this stay is not going to apply. And this makes sense if you're dealing with, maybe a sole source or particularly an emergency contract. But you just have to be aware if you're dealing with an invitation for bid, even if you protest, there's no requirement for the procurement official to stay during that bid protest, meaning that you could go through this process, and at the end of the day, you're only going to get your costs, and you may not have a chance of getting the contract. The procurement official now will only make a decision as to material issues. This idea, this definition, this principle of material issues is something that is new in the code this year. The code defines material issues as a non-trivial defect in the solicitation or award that would prejudice the outcome of the procurement. And it also goes on to say, though, that if you have multiple trivial defects, it doesn't necessarily mean it rises to the level of a non-trivial issue. What we look at is, did the issue really prejudice the outcome of it? Meaning, did what happened change, particularly the award of solicitation? So, as an example, did an agency's use of an evaluation criteria that was not specified in the solicitation result in John Doe Corporation not getting the award? That would be a non-trivial defect. So if a vendor or contractor is unhappy with the resolution of a bid protest by the procurement official, so we assume the procurement official denies the bid protest, that vendor or contractor then has 2 options. Option number 1 is that procurement or the vendor or contractor can go to the executive director of the DPA, so the Department of Personnel and Administration. Or second, the vendor or contractor can go to the Denver District Court. Now, only material issues can be appealed, and again, we come back to that definition. This is something that they're trying to, I think, cut down on issues that are raised, issues that are decided on, and issues that go up on appeal. Again, we also have another provision here for stays, or contracts not being awarded. Now, here it's a little different. It still applies only to requests for proposals, but we do have a limit in the amount of the contracts for which the stay will apply. It only applies for contracts of $1.5 million or more. Now, it does provide that the executive director of the Department of Personnel Administration can override the stay if it's in the best interest of the state. Again, that could be a fairly low hurdle because there could be a lot of things that could justify having to move forward without having a stay. And I put this in here. There could be a question as to the scope of this. The section that this stay is put in the code is in the section related to the appeal to the executive director. However, the way it's worded, it talks about any appeal pursuant to this certain part of the code. And another part of this code has to do with appeals to the Denver District Court. So someone could make the argument that the stay may apply to bid appeals to the Denver District Court, although I think the way it was intended and with some other provisions in the code, that's probably not likely to be what the court is going to accept. So I think you need to assume that if you appeal to the executive director, you could receive a stay for a certain amount for RFPs, as long as there's not an override. But if you go to Denver District Court, don't anticipate getting a stay. And I say this for another reason, in that in some of my discussions with during the legislative process, I think this was their intention of steering contractors to using the bid appeal process through the executive director as compared to Denver District Court. So this was provided as kind of a carrot to using that method as compared to running off the court. So the first option is the executive director of DPA. Currently, this is June Taylor. Although Ms. Taylor might not necessarily, and probably given her schedule, is not going to be the person specifically deciding your bid appeal. The code provides that she can designate another person to deal with this, which odds are may be the chief procurement official. It could be another person. The person deciding the appeal will review the bid protest decision, but it's not going to be de novo anymore, meaning they're not going to look at it with fresh eyes. They're going to be looking at it through some other standard, which is probably going to be based upon another provision in the code, either clearly erroneous or arbitrary or capricious. These standards are a lot more deferential to the agency that made the decision of awarding a contract or any other contract action. There's a new provision this year in that instead of even DPA deciding it, they can refer it to the Office of Administrative Courts, which will then use administrative process to decide the bid appeal. And there isn't a whole lot more detail on this other than it makes reference to the Office of Administrative Courts, and it then refers to the administrative procedures that are already enacted that would decide how that process goes about. The appeal also is only limited to material issues again. So we can't have any trivial issues that can be decided. And another thing they brought in this year, and this may be due to historical issues, is the appeal is only limited to conduct associated with the bid protest. So you can't, the appeal is only limited to material issues that are raised in the bid protest. So you can't raise any new issues that were not raised before. The exception is if there's any conduct with the bid protest that a vendor or contractor thinks violated some aspect of a code. And so the important part of that is if you're filing a bid protest, to make sure you put everything in there that you think might be a reasonable, non-trivial ground to protest. Because if you don't, you'll be later barred from arguing that on an appeal to the executive director. Timelines. Originally, you had to file a bid protest. Now you must file a bid protest within 10 business days. Previously, it was 10 working days, small change. And the decision must be done within 30 business days. It's not a whole lot of change here, mostly just having to deal with working versus business days. The second option, and this option existed previously and it still exists now, is Denver District Court. You can appeal two things in Denver District Court. Where you can appeal first the bid protest denial. So instead of going from the procurement official to the executive director to then the Denver District Court, you can take your appeal straight to Denver District Court. And you can also take your appeal to Denver District Court any time after you filed your bid appeal with the executive director, his or her designee, or any time it's with an Office of Administrative Courts. So if you file with Denver District Court, what happens is it just divests jurisdiction with the Executive Director, and you move on to Denver District Court. The second instance in which you may find yourself in Denver District Court, if you so choose, is after the Executive Director, his or her designee, or the Office of Administrative Courts, if they deny your bid appeal, you then have another appellate right in Denver District Court. The time frame for this is 10 business days after the decision is made. However, there's no firm decision deadline. So unlike with the bid or with the procurement official or the Executive Director, no one can really tell you for sure when the decision will be made. And the reason is you're now in state court that has certain processes. You're subject to judges' calendars. And even with it, when the matter is fully submitted to a judge, there's nothing that necessarily requires him or her to rule in a certain time period. So you could be looking at several months, half a year, even a year, depending upon schedules and the complexity of your bid appeal in Denver District Court. So the procedures in Denver District Court, I mean, there's no changes in the sense of the Colorado General Assembly cannot and didn't make any changes to how the Colorado Rules of Civil Procedure are followed for this. So we're still following the same rules of civil procedure. And I put this bottom subpoint here is a question as to preliminary injunction under Colorado Rule Civil Procedure 65. And Colorado Rule Civil Procedure 65 normally provides that courts can issue preliminary injunctions. And what a vendor or a contractor would normally ask a court is, during the pendency of this bid protest, we would like you, the court, to not let the agency proceed with this contractor who won because there's going to be irreparable injury to my company. And there's been some recent rulings, albeit informal, not subject to appeal. They're not authority in which you can totally rely, but there's been 4 or 5 decisions from the Denver District Court, all similarly ruling that they don't have authority to issue preliminary injunctions on bid protest appeals. And I've argued this issue, and there's not really a whole lot of law one way or the other, and I have an appeal ongoing to find out if this is in fact the law or not. But in the interim, you should assume that if you're in Denver District Court, which is the only court you can be in for an appeal, is that you have no preliminary injunction right, meaning that there's not going to be a stay of the contract moving forward while you continue with your bid protest appeal. Previously, the standard of review had been de novo, meaning the court was going to look at this anew. It wasn't going to rely on any previous decision of the agency and afford any kind of deference. Now, this is one area where I will definitely say it is kind of an unknown. The language of de novo was stricken. It's purposely left unclear, as I understand it, from individuals at DPA. However, there is another provision in the Procurement Code which suggests that agency decisions are final unless it's clearly erroneous, arbitrary, capricious, or contrary to law. So what DPA has suggested is this leaves open some room for everyone to argue one way or the other. So contractors obviously going to argue if there's a de novo standard, the court should look at this on its own and not afford the agency deference. The agency obviously is going to argue the contrary, saying it previously was de novo, that was stricken, and there's another provision that provides these deferential standards. If I had to argue this and I had to guess, I would say courts are probably more likely going to look at the way the CGA struck the language, and based upon this other language, is probably going to give the agency this deferential standard. So while it's unclear, I think vendors and contractors need to assume that courts are going to be applying a much more deferential standard. Now, this isn't something totally surprising to anyone who does government contracting, because if you file a bid protest with the Government Accountability Office, they also generally afford agencies a deferential standard. And nor is this something that's very controversial. It's just something to be aware of this change. Now the remedies. The remedies is another area of bid protest that also has substantially changed. First has to do with remedies for interest. So this has to do with all types of issues for which a contractor might appeal, so bid protests and contract controversies. Previously, interest accrued when the payment was due, and obviously that could be subject to a lot of disputes as to when was payment actually due. The CGA has clarified this and probably reduced significantly the amount of interest, saying interest is only due when the controversy is submitted to this process. Previously, the rate was 11%. Now we have the interest being greater of either the contract rate or 1% per month. And I'm going to guess you're probably going to see very specific contract rates being a lot lower to reduce any potential interest that the government might owe. The other areas have to do with what are the remedies if there's been a violation. The first part isn't any change. So if a bid protest or if a procurement official, executive director, finds there's a violation prior to the award, the solicitation or the proposed award is just canceled or it's revised. However, this decision is not subject to any review. And this is something that is new, although I don't think it's really something that's that controversial. The other has to do with probably the more likely remedies you're going to be dealing with a bid protest is what happens if there's already been an award. So depending first on if we're having a procurement official or executive director, and again this is option 1 as compared to the Denver District Court, under this option that person can cancel or terminate the solicitation or award. That's the first option. Second, they can modify the solicitation or the award. Or third, they can actually ratify that solicitation or award if it's in the best interest of the state. And this is something that is, I find interesting to the Colorado Procurement Code is they can find a violation, albeit something that can be fairly extreme, yet they can find it's in their best interest to proceed forward. And again, that can be a fairly low hurdle to meet to move forward despite being a procurement violation. And the aggrieved party, so the person who files the bid protest or appeal, if it's ratified, all they get are costs if they had been awarded the contract. And there's a caveat here, and this is the last point that contractors should be aware of. If they accept these costs from a procurement official or the executive director, they waive any right to appeal. That probably should be obvious at that point if you're accepting the cost. So this is probably something that's more just making this express, in that if you accept their costs because the contract's ratified, you can't move on to the next process. Now, under option 2 of Denver District Court, this is where you've seen a significant change of the remedies. Before, there was this question of the way the language was written as it didn't define who would decide the remedies. It would say that the contract could be terminated, canceled, or it could be ratified. And vendors and contractors argued, no, you, the court, have to decide this based upon the way the language of the code and the structure of it. And the agencies argued that, no, we, the agency, are the only people who can decide what's the best interest in how to deal with the contract. And what the Colorado General Assembly now has done is taken the agency's position. And so the remedy is if the Denver District Court finds a violation after award, all they can do is direct the executive director or his or her designee to determine whether he or she should ratify, terminate, or cancel the contract. So the court does not make a decision. The court does not make a recommendation. The decision is solely done by the director, and as you can see by this bold and underlined provision here, and this is something that's new to this, is that decision is not reviewable under any standard. So once the court decides this, it goes back to the executive director or his or her designee, and that person makes a decision on whether to cancel or ratify, and no one is going to review that. And again, if the contract is ratified despite there being some kind of egregious violation, the aggrieved party only is entitled to costs. So I've mentioned this term costs, and you're probably thinking, gosh, I could probably get a lot of money out of this, attorney's fees and everything, lost profit, consequential damages. The unfortunate part is that's not the case. Costs only mean reasonable costs incurred in connection with the solicitation. And the code previously had defined this, and there isn't really much change to this, meaning you get your bid preparation costs, but you do not get any attorney's fees. So you cannot get any attorney's fees for filing a bid protest or for filing a bid appeal. And the statute also says there's no other costs allowed. So there's not a whole lot of costs that you're going to get out of successfully winning a bid protest or bid appeal, unless you obviously, the ultimate remedy you want is to have that award terminated and have the agency take some other action. Now, the costs are solely determined by the procurement official or executive director. So even if you have the Denver District Court finding there's a violation and directing the executive director to take some action, that court is not going to decide what costs you get. So what is the practical effect of these changes in bid protests and appeals? If I haven't been obvious enough in some of my comments about this, there are some good to this. One is there's more protection with contracts not being awarded or stayed. So they have extended the umbrella for stays of contracts or awards while protests are dealt with by procurement officials or the executive directors. In one of the initial versions of the statutes, the CGA initially had vendors and contractors having to put up bonds for some of these stays. That language was later withdrawn. So we at least now have general stays, why these are resolved, at least by the agency. And that's definitely, and there's no argument by myself, that that's a very good thing. However, Denver District Court is really less of a viable option. And it's not viable in the sense of you can go through spending the time and the money in Denver District Court, but at the end of the day, all the court can do is find a violation and kick it back to the executive director to decide what is the remedy. And that decision by the executive director is not reviewable. So the last bullet point is probably ultimately what's the net effect of this is the best option now for procurement, or the best option for vendors and contractors is the bid protest with the procurement official and the bid appeal with the executive director. So my recommendation to vendors and contractors is when you file bid protests, that is your audience, and that is the person you need to convince. Is you want to convince them, the agency, that respectfully there has been a mistake made and you should fix this. Because the option of Denver District Court doesn't provide you with a stay and doesn't really provide you with any remedy. Suspension and debarment. Obviously, this is the nasties of the nasties in government contracting. There isn't really a whole lot of changes to the grounds by which a contractor or vendor can be suspended or debarred. We just have some small changes here. One is instead of the head of the purchasing agency making the decision, it's now at a slightly lower level of the procurement official. You still have all the normal due process requirements of hearings, and if you look at the bottom here, you still have the same appeal process of going through the executive director and going through Denver District Court. So you're not going to have agencies under the new House Bill 17-1051 suspending you and debarring you without due process. And there is one small change, and hopefully this doesn't apply to anybody on the phone or anybody who has to deal with this, is the debarment period is now longer if someone's convicted of a crime and they're sentenced and have a probation period. Other than that, there's not a whole lot of changes in the suspension and the debarment process. Contract controversies. So contract controversy is defined as, and this is the way it's in the code, is a breach of contract, mistake, misrepresentation, or any other cause of contract modification or rescission. So essentially, any dispute between the government and the contractor, again, alleged breaches of contract. This could be disputes over change orders, differing site conditions. And so what the statute provides is if the contracts can't mutually resolve this amongst themselves, the vendor or contractor can submit this to the procurement official for an official decision. And then that procurement official then has 20 business days as compared to 10 with the bid protest procedure to make a decision. If the vendor or contractor is unhappy with the procurement official's decision, you still have the same appeal process as you do with bid appeals. So you can go to the executive director, they can kick it to the administrative courts, or you can go to Denver District Court, except now you have a little more time period in which to file with the executive director. Confidentiality and CORA. When we talk about CORA, we're talking about Colorado Open Records Act Records Act, and this has to do with that our government is supposed to be transparent as to public records and make them available to the public. Now, the prior law relating to government procurement was that bids and proposals were subject to CORA, and the Colorado Procurement Code specifically stated this, and there was no dispute about that. However, when you actually looked at CORA, which is in a separate section of the code, there was some exceptions that applied here, and the two main ones were trade secrets and confidential information. So obviously contractors and vendors could argue that much, or at least some of their bids or proposals were trade secrets or confidential in the sense of our specific process of building something is something that we don't want our competitors to know, or our prices is definitely something we don't want our competitors to know. Now, the problem with the previous method is the burden was on the contractor to have to justify that if there was some kind of dispute under CORA as to whether that applied or not. And so this is an area in which I will definitely agree the Colorado General Assembly made some positive changes. And there's two areas, and these are very different. You're going to have to be mindful of this. So first we have market research, which we talked about earlier, that the agencies can conduct market research before they pick their method of selection of a contract. Now the code now says that those responses are confidential until after the award. So if you provide information to an agency, at least according to law, you shouldn't have to worry about that information being leaked to a competitor or the public. However, the caveat here is that information then is subject to CORA after the award. Now those provisions and exceptions would still apply, but I would warn that you're going to need to be careful in submitting information to market research, because we don't have a blanket exception to CORA. You are going to have to argue and justify that information is privileged or confidential. So it'll be a fine line to walk for contractors of how much to give to an agency in market research while being mindful that those records will later become public, and you have to worry about the public, or particularly your competitors, learning that information. And the second part, and here's the real good news, at least in confidentiality and CORA, is proposals and bids are not public records and they're not available to the public. So what we're going to have is, during the process, the agency is going to create a register of proposals and bids that will be available for public inspection after award. The code doesn't really get very specific into what exactly that means. You know, what is a register? Is it going to be the names of the companies, their addresses, their phone numbers, and what's the total bid amount? It may not even be the bid amount, because under federal contracting, often that information isn't even public. And what the code says is the executive director or his or her designee is going to promulgate rules on this. So after this goes into effect on August 9th, you can probably anticipate we're going to have some regulations coming out. And to the extent those come out, we'll keep you up to date with client advisories. One of the latter areas is preferences and goals. Now, what the General Assembly did is they just created a new title under the section called Procurement Preferences and Goals. And this was pretty logical in the sense of there were a lot of preferences and goals. Some of them were in the Procurement Code, some of them were out, some were in different sections. It didn't really make a whole lot of sense where they were. So what they did is they combined them into really one logical section. There wasn't a whole lot of changes to these preferences. Now, unlike federal government contracting, when you have a lot of preferences for socioeconomic categories, there isn't a whole lot at the state level. And I list some of the 5 main ones here. One have to do with low tide bids, and then this goes to what we'll talk about, resident bidders. You have environmentally preferable products, preference for state agricultural products, service-disabled, veteran-owned small businesses. This is fairly comparable to the federal system, albeit the goal that the state uses is, I think, only 3% of contracts. So it's a very low. You don't see a whole lot of these at the state level. And then you have a bid preference for resident bidders. And that probably tends to be one of the issues and preferences that people care the most about. So there was one or two changes to resident bidders, and this had to do with businesses. Previously, the requirement was a business had to have its principal place of business in Colorado, and that could eliminate some businesses from being a resident bidder and getting a preference, and that would tie into the low-tie bids and tie into any preferences for Colorado resident bidders. The change now is you just need a place of business in Colorado. Now, of course, they try to keep businesses from gaining it through the Colorado unemployment compensation provision, and there was merely just a change. The previous percentage led to mathematical computations that led to non-whole numbers. So now you just have to have paid unemployment compensation in 6 of 8 prior quarters. So this is good for businesses that don't have a principal place here who want to be considered a quote-unquote resident bidder. And before I go to questions, there is one last area that I didn't include in my slides, and this is having to do with the requirements to maintain documents and audits. Previously, the requirement was you had to maintain documents for 3 years after the contract was completed. They've now increased that to 6 years, which I personally view as quite a long period of time for a contractor to have to keep documents. And the corollary to that is the state can now audit you for 6 years past that. So not only do you need to keep that because it's required of the statute, and they could do some of the nasties to you, but for 6 years past contract performance, the state can now come back and audit you. So you are going to have to keep your documents for 6 years, which is a long time. And obviously for larger jobs, that may be a substantial expense of keeping off-site records. So that's the end of the presentation. We're now going to open it to the Q&A, and I'll get some questions and answer those.
Ryan, hey, thanks for that presentation. There are a couple of questions that have been submitted, so let me present these to you. Why don't you give a short answer? We've still got another 5 or 6 minutes of time. You were talking about preferences and resident bidders. Generally, are there any affirmative action requirements built into the Colorado Procurement Code, either in terms of hard requirements or even objectives or goals?
So we do have some goals. You have the service-disabled veterans. Other people have, disadvantaged businesses, and they have certain subcontracting goals. But we don't really have it at the level of the federal government contract and how much they require of socioeconomic categories. So it's more built into a lot more of CDOT and other municipalities as far as preferences, other than the ones I just identified. Those are the only ones that are codified.
Thank you. When you were talking about bid protests, I think the conventional wisdom is they're difficult anyway. Has there been a fundamental change in everything that you went through that makes it even now less of a viable alternative to pursue?
And it's a good question, and obviously I spent a lot of time on it. Bid protests are always difficult. You always have the question of should you be disputing an issue with a company for which, not company, an agency with which you want to receive a contract, you want to do future business. It's always something that you have to decide. And I think the way they've changed it is they've certainly shifted it from making Denver District Court the option and pushing you into the agency. So it's still a viable option. I think you just have to change the manner in which you do it is you have to convince the procurement official, the executive director to make the change. And that was kind of their intent and their focus. So it's really retooling how you do it and focusing on that. It probably will ultimately reduce the amount of bid protests, and that may have been the intent, and that may be good or bad for the industry. But it's something to keep in mind when you're filing these is who is your audience and how going about getting the best results for your company if you're going to file a bid protest.
And let me just follow up on that with you personally from your experience. At the end of the day, is a successful bid protest worth the trouble, or like you mentioned, are you biting the hand that feeds you?
So sometimes you have this odd process of you have to file bid protests if you have an ambiguous solicitation. If you don't do it before you file or submit your proposal or bid, you are later stuck in suggesting that a solicitation is ambiguous. So sometimes you have to do it, you just have to be really respectful. But sometimes you just have a decision that, or an award that wasn't properly made, and you may make the decision that you just need to do it in the hopes that the agency will take the right action and maybe you get the contract award. But obviously, even if you win the bid protest, if the executive director says that you were right, there's a violation, there's just no guarantee. So I think it's something that each company has to weigh of potential downfall with the agency, the outcome of it. But I think if there's an issue with solicitation, you need to think long and hard of, you can't lie in wait and argue there's a defect later on because you're going to be stuck.
Thank you. We've got two more questions. We'll see if we can fit them in a couple minutes here. You talked about this 6-year records retention policy. Can you comment on the scope of that? Does it apply just to the state contract, or is it broader and cover entities like CDOT, counties, municipalities?
So again, the procurement code only applies to the way it was defined at the beginning. It's all governmentally funded projects by the executive branch of the state of Colorado. So it does not apply to CDOT. CDOT has their own regulations and they have their own requirements. The code doesn't apply to municipalities, so counties and cities. Most of them have their own procurement codes, and some of those vary from either following our code or to being completely something of their own making. So this requirement's only going to be a 6-year requirement for the procurement code. So it will not apply to CDOT, will not apply to municipalities.
Okay, we'll take this last question. This comes out of the ethics information that you discussed. As a construction company that does business with the state, should we be rethinking the way we deal with government officials and be ultra cautious in light of the ethics information, or is there really no fundamental change in how you deal with government officials?
I don't think there's really a change yet, in the sense of government officials still have to follow those 16-page guidelines or principles and guidelines. So, they shouldn't be receiving tickets or meals that are in excess of certain amounts, and they shouldn't have interests, and they shouldn't be giving you information. But I think what we have is maybe the state looking at moving towards more of kind of what the federal government has, of having ethics requirements of companies themselves. And you may have the executive director promulgating rules by which companies themselves may have to start putting in their own codes, which you have in government contracting. So we don't really, unfortunately, have any guidance yet. We just are supposed to be following the highest levels of ethical guidance, which really kind of means nothing. So I'd say companies should keep doing what they're doing and just kind of stay tuned to, once this goes into effect, we're probably going to get some guidance, because it's kind of one of the big issues of this bill was ethics and training. I think the executive director is going to give some guidance and rules and regulations, and Sherman & Howard will send out a client advisory if there's more specifics. And if there's enough of specifics, we may even do another webinar or some other more detailed client advisory to give you more guidance in that area.
Thank you, Ryan. That was a lot of information to digest in an hour. So to those of you listening in, feel free to contact Ryan directly at any time in the future about this webinar specifically, or for any help you may need with government contracts issues. As a reminder, we did make an audio recording of this morning's program, so keep an eye out for our follow-up email to you with that recording and a copy of Ryan's PowerPoint slides. We hope you're able to join us for future webinars in coming months. Ryan mentioned the current legislative session wraps up shortly, and we'll be breaking down all the legislative changes that affect the construction industry in a webinar next month, and then discussing the use of drones on construction sites in a webinar in July. Thank you for joining us today, and have a great week.